Welcome to Lawyers Without Billboards, where we break down family law and other areas of the law. No gimmicks, no legal jargon, just real, unfiltered talk from real lawyers. Join your hosts, Steve, Patty, Jimmy, and Alexa, partners at Shewmaker Lewis, a law firm based in Atlanta, Georgia. Every episode, they tackle the legal questions that matter most: divorce, custody, child support, alimony, and everything in between. They'll pull back the curtain to give you real insights on what happens inside the courtroom and beyond.
Hey everybody, Steve Shewmaker from Shewmaker Lewis, along with Jimmy and Alexa Lewis and my wife and law partner, Patty. And today, today, Patty, on this fine, beautiful September morning, I think you're going to talk about our guest.
We have a special guest.
Special guest?
Yeah, special guest.
Special guest.
Special in so many ways.
Special house.
I'd like to
Y'all have your own answer to that question.
I know, right? It's a loaded question. We like to welcome Jim Holmes. Jim Holmes is special to us because Jim, we've talked in other episodes about mentors, and Jim has certainly been a mentor to all of us. Probably, certainly longer to me and Steve. When we first started practicing, Jim was a mentor. In fact, I got to tell a funny story about this because we're going to talk about guardian ad litems this morning with Jim, but Jim also does a lot of mediations. And I first became aware of Jim, just became aware of him. Didn't meet him, but became aware of him one morning before I was an attorney. And Steve is getting ready to go to work as an attorney. And he is just furiously polishing his shoes, like we're back in the Army or something. And I was like, what are you doing? And he's like, well, I got mediation today. He's like, and my mediator, he's this retired Navy officer. And the last time I had mediation with him, he hazed me because my shoes weren't shined. So that was my first impression of Jim and how I first became aware of Jim. And that was, gosh, that's been, 17, 18 years ago now?
Yeah, that would have been in about 2007.
Yeah.
He could have done better if he'd worn combat boots that day.
Maybe so.
So Jim has been a longtime mentor of ours. Jim is now also of counsel to the firm and has been since 2012. Jim, for a long time, did litigation, did business divorces, family law, now does guardian ad litem work, also does mediation. So this is our third superhero mediator on the show?
In the series of superhero mediators, he is the third one in the row. Doesn't mean he's third best. Nope. We only get the best on here.
Tesser and Flink were.
That's right, Flink Daddy, and
Lewis, your fellow guitar player.
That's exactly right. And now we've got you.
I don't play.
So Jim, and of course, we would be remiss if we didn't mention his better half, Margaret, who keeps him in line.
Who was a calendar clerk for Judge Seeliger for 28 years.
Yeah, she worked in the court system for a long time. So she tells us, what not to do and what to do when we deal with court staff and, gets on us about that. Certainly keeps Jim in line, makes him come to work.
I have no hobbies.
And we actually vacation with Jim and Margaret quite a bit.
We do. Jim and Margaret have been like another set of grandparents to our daughter, Molly.
Absolutely.
So, Jim, welcome. Thanks for taking time out on it.
Thank you for not only this, but for a lot more. And we'll go there someday.
Okay.
When y'all answer me and tell me how I'm special, I'll tell you why I'm saying thank you.
So let's just get this out of the way. Jim, are you from Macon?
No, it does start with an M.
Where are you from, Jim? I mean, I'm sure there's at least two people out there in the world that don't know.
Moultrie, Georgia, Colquitt County.
Okay, where's that? Nobody knows what that is.
60 miles due north of Tallahassee, about 40 miles southeast of Albany, and about 40 miles west of Valdosta.
So you're basically a Floridian.
No.
But y'all got a lot of gnats down there.
A lot of gnats.
So you're basically square in the middle of nowhere.
Yeah.
You're like 2 weeks from every place. Okay.
In fact, you mentioned my wife. I took her to a reunion for my high school class, and we were eating out of doors, and she started noticing these little specks in her potato salad. And I said, Margaret, it's only high protein.
That was
That wasn't pepper.
How old are you, not you?
I don't go there, Steve.
Oh, okay. All right. I was just going to say, when the high school reunion happens and you're the only one there, I'm just like,
I hope not.
We love you, Jim. We love you. All right, Patty, keep going.
All right. So yes, Jim is a mediator. Jim's a great mediator. In fact, before he became a counsel to us, he was one of our favorite mediators.
Most attorneys in domestic law who do mediations are it's fairly common for them to use the same handful of mediators, probably 3 to 5 mediators. And Jim was the first mediator I ever used, and he became my go-to mediator whenever I could choose. I chose Jim. And it was like that until 2012 when he decided to join up with us, and we all said, look, you could join up with us, but that means you're not really going to be mediating for us anymore. And he did it anyway.
Yeah, maybe he was.
I've kept count of the number of mediations you've done that haven't used me, and you will get my bill.
Okay.
Well, one thing that I do appreciate about Jim is a lot of his mediation practice also outside of family in the business sense of things. Yeah. And so Jim's a wonderful resource for that when talking about small businesses and kind of dividing up some of those.
Right. A very broad base of experience, which is very useful in family law.
And y'all talked about that with Andy too, because he has sold a business.
Yeah.
So Jim's very valuable to us. Is that what you meant before we started the podcast, Jimmy, when you said that Jim was such a tool?
One of the meanings, very similar to special.
I'll go with that. I don't want to talk about...
Yeah, this is not about Jim Holmes. Yeah.
Well, no, it is about Jim Holmes and your perspectives. But I don't want to talk about mediations because we've had a few episodes about that. What we haven't talked about yet, that does come up a lot in family law cases, and we deal with a lot, is guardian items. Jim, how long have you done guardian item work?
I was thinking about that, Patty. I think my first guardian ad litem case was in the early 90s before guardians were even in vogue. And Judge Phil Etheridge asked me to do a guardian ad litem investigation and make a report to him. I made a report finding that it was a modification case.
Okay.
It'd be best interest to change custody.
Yeah.
And he disagreed with me because he didn't find a material change of circumstances.
And that was your first guardian?
That was my case. First case.
First case ever. Yeah. And how many just, and I know you may not know the exact number, how many do you think you've done over the years?
Somewhere between 150 to 200 cases probably.
I would guess more.
Maybe. I don't know. I used to do a lot at one time. I had as many as 8 at one time.
That's a lot.
And I cut it down to where I was only doing 3 or 4 because I couldn't remember who the kids were.
Well, and we'll talk about this. It can be intense, but let's kind of start with the basics. Explain for our listeners, because some of our listeners are lay people. What is a guardian ad litem?
It's when y'all were talking with Andy about mediation and arbitration, he called arbitration as court light. Guardian ad litem's kind of guardian light. You don't really have real authority over the child or anything. So you're an officer of the court. You're appointed to investigate and to make a recommendation to the court as to what's in the best interest of the child. I like to look at it this way. Mom has an advocate. Dad has an advocate. The kid needs an advocate.
Okay, let me stop you right there. Do you represent the best interest of the child, or do you represent the child?
I represent the best interest of the child. We are not the child's lawyer. And that's for primary reason is because what the child tells us is not necessarily confidential. And if we were the child's lawyer, we would be bound by confidentiality.
Yeah. Okay. And sometimes, and I'm sure you've had cases like this, where the best interest of the child doesn't necessarily line up with what the child wants or thinks he or she wants.
That's right.
Yeah. Have you had those cases?
I have. And you come to that conclusion not from listening to the child, not from listening to the parents, candidly, but other people that know the child, such as school teachers, athletic coaches, counselors that have spent a lot of time with the child. But yes, I unfortunately have made recommendations sometimes that are not consistent with the wishes of the child, and I try to be upfront to the court about that, especially if the child is old enough to have signed an affidavit but elected not to.
Okay. So, all right, you kind of touched on this a little bit. You said the court appoints you. Does a judge pick you? Do the parties pick you? How do you get selected?
Initially, it was being selected by the court.
Okay.
At least that was my experience. Now, more often, the guardians are selected by the attorneys and a consent order is submitted to the court.
Okay.
I used to only take cases in which I knew the judge or I knew the judge knew me, because then that would give me some credibility with the court, or I knew the attorneys and I knew I could work with them. And there were some I didn't take because of...
Oh, and there's some attorneys you can't work with.
Exactly.
Name them.
No. Well, let me ask you this. Do judges always accept who the parties or the attorneys pick as guardian ad litem?
Not necessarily. I don't know of many, but I'm hearing more and more where the judge has their go-to guardian ad litems, the people they like to hear from and the people they trust, and they would rather do that than go with the attorney selection.
Yeah, Jimmy or Steve, have you guys had that in any of your cases?
Jimmy?
Where either the judge says, no, we're going to use it somebody else. We're not going to use who you guys agreed on.
No. I don't think I've ever encountered that. I feel like a lot of times judges are just kind of like, yeah, if you guys agree to it, that's fine. I know a lot of judges certainly do have their lists of their go-tos, and maybe that's because of prior professional relationship that they just trust that person is going to do something new. And of course, we've all seen judges who getting them out of their comfort zone and including somebody else in an order that isn't one of their go-tos is just earth shattering. But no, I can't think of anything right offhand where a judge has been like, no, I'm not going to do that. I'm doing this.
For me, if I've ever had a judge reject a guardian that the other counsel and I picked, then I don't remember. But I'll tell you, and you guys are probably going to get to this later, I don't do guardian work. That's something Patty does, and your mentor into guardian work has been Jim. Yeah. Okay, which is one of the reasons it's such a pleasure to have him on here. And Jim's been a mentor to me in how to mediate, shining my boots and my shoes, and
unpacking things,
and how to mediate cases, because I became a mediator a couple years ago, and Jim mentored me there. But I don't intend to become a guardian. It's not something on my radar right now. But so I deal with guardians. So like next weekend, I'll be at the Guardian Ad Litem conference down in Savannah. But I look at it from the point of view of understanding these space aliens, these very foreign things, these guardians.
Well, think about it this way. The guardian is only making a recommendation. It's not binding on the court.
Well, I'm glad you say that, because I would say there's a small and growing subset of guardians who think they are sacred and think that
they're the judge?
Yes, and Patty knows what I'm talking about, and you probably do too.
But in the context of judges appointing the people they know, they are looking to a guardian on which they feel comfortable basing a custody decision.
Yes, sir. And that's...
If they don't feel comfortable with the guardian, or if he or she's a stranger, the judge certainly has a right to appoint his or her own guardian.
No, the judge has the first right. Yeah. It's the judge's privilege. But now, from the standpoint of somebody who deals with guardians all the time, what I think is interesting is it's always the same playbook. The guardian issues a recommendation, could be verbal or written. It either favors one side or the other, or comes up with some sort of hybrid solution that nobody likes. So I'm talking to my client who is not happy with what the guardian's doing, either because my client's going to outright lose, or the guardian wants to force some different sort of plan on both of them. And it's always the same thing. What are we going to do to get rid of the guardian? And my answer is always the same. It's like, okay, in 20 years, I've had one guardian removed. It is so rare, because you either did what Jimmy just talked about. You consented to this guardian. You came to the judge and said, Judge, we want Patty Shewmaker as our guardian. How are you going to look at the judge now and go, Patty Shewmaker's insane. She's crazy. You shouldn't listen to her. Or worse, the judge says, Patty Shewmaker's my go-to. She's on my list. I've appointed her. How are you going to go to the judge and go, Judge, your decision is wrong? Okay. So I tell my clients, you don't like what the guardian's doing, you're not going to win any points with the judge by outright combat with the guardian. You've got to be more subtle than that. And that's a whole different topic.
Yeah, and that's hard to do.
One thing, y'all talking about my mentoring you, or y'all, let me give a quick shout out in recognition to Diane Woods, who was my mentor many, many years ago. So I just need to get her name in there.
Oh, shout out to Diane.
Shout out to Diane.
So Diane taught you stuff?
She did.
So you can't teach an old dog new
You
tricks.
can't. I wasn't that old then.
Okay.
So I have had a judge where the party said, here's our consent order for a guardian litem. We agreed on the guardian litem, and the judge come back and issue another order appointing somebody else.
Do you feel comfortable saying who the judge was?
No.
Okay.
No. And then I've also had a judge where both attorneys said, we need a guardian ad litem, and we even asked the judge, who do you like? Who's your go-to? And the judge said, no, I don't like guardian ad litems.
Yep. I've had a judge say, I don't like guardian ad litems. I wear the black robe. That's what they pay me to do.
You could put the evidence up in front of me and I'll make the decision.
And there's nothing wrong with that. It is the judge's privilege, as I said, to appoint a guardian or not. But one of the things I like to say to parties is, I don't want to bring your kids into court. And I think we've all been there where we had to bring a child into court. I'm not talking about a 2-year-old, but you bring a child into court and say, Judge, I'd like the child to either testify, which is really the worst thing you can do, or to talk to the court in chambers, talk privately with the judge. One of the great things about a guardian is you can avoid that. And if I have a judge who says, I don't want a guardian, then my response might be, very well, Your Honor, but I anticipate I'm going to have to bring this 12, 13-year-old child into court. How does the court feel about that? And then I would expect the judge to say, in chambers is where we'll do that.
And before guardian ad litem, you'd have to bring the school teachers, the doctors, the pediatricians, the counselors. All of them would have to come to court and testify.
Well, that's another very interesting point. And thank you for bringing that up, because on a previous episode we recorded today, we talked about temporary orders, and we were talking about them from the perspective of evidence law, which is kind of one of my things I like. A guardian, as I explained to my clients, is a rarity in the law because hearsay is prohibited in court. You can't come into court and say what somebody who's not there said. In fact, technically, you can't say what somebody who is in court said. They have to get up and say it on themselves if you want to get really technical. The guardian is an exception to the rule. The court allows the guardian to go out, and because the guardian is theoretically neutral to the parties' best interest of the child and is the court's expert, the guardian goes out into the community and talks to coaches, teachers, neighbors, other people, and then issues a thorough report and does carry hearsay into the court in the report and in the testimony of the guardian, which is an exception that you cannot say, I object to the guardian's testimony about what the neighbor said because that's hearsay, because the judge will say, is this your first case, Mr. Shewmaker? The guardian is allowed to do that.
In fact, Uniform Superior Court Rule 24.9 that deals with guardian ad litem designates the guardian as an expert.
Right. The court's expert, representing the best interest of the child, who can basically be a conduit of hearsay. So you have to embrace where the guardian is helpful. The guardian can call or even visit people out of state that you can't get here to testify in court. I mean, there are times where you've left the state, Patty, haven't you, as a guardian?
Yeah.
Jim, have you?
Yeah, I got to sit in a B-2 bomber up in Minot, Minnesota or Montana.
Well,
Patty, where did you go?
Fort Bragg.
North Carolina?
I know.
The bomber didn't take off while I was sitting in it, but I did get to sit in it.
Haley, in the last year, one of our associates,
Haley Settles,
who's doing guardian work, she's been to Florida on one and been to Kentucky on another.
And let us not forget our friend Aisha Blanchard Collins, a Decatur guardian, who actually had to go to Lagos, Nigeria.
That's right.
Nigeria as a guardian. Okay.
I want to back up because we've kind of hinted around this. But Jim, why would we want a guardian ad litem in a case?
I think sometimes they pull the trigger too soon, and you don't necessarily need a guardian. And
But why would you want one?
Yeah,
Why might you want one?
you would want one so that all sides get a fair airing of all their issues and their opinions, and you're not getting the slant from the mom or the dad. In most custody cases, everybody says, I want what's best for my child. I want
We all just have different. We just have different
with definitions.
What
That's right.
is best?
And so the only way to sort that out is to either both attorneys talk to everybody, so running up fees again, or you have one person that does the consolidated effort to get all that input and then make a recommendation.
Okay.
And I think it comes to a better resolution as to what's best for the child,
Okay.
because it gets rid of all the biases or prejudices that anybody may bring.
Well, don't guardian litem have their own biases and prejudices?
Yes. Yes, and that's one thing you have to watch out for. You're not trying to set your own parenting standard on this family.
Yeah.
You're trying to determine what's best for this child within this family
Sure,
dynamic.
because everybody has their own biases, prejudice that they bring to the table,
Sure.
regardless of how much we try to.
Exactly.
Either of you as guardians ever taken a bias test to find out what your biases are?
I have not. Have you, Jim?
Only when I was, no, I haven't. I was getting ready to say
But I will tell this, for those of you who don't know that and people are listening, Jim and I do a lot of co-guardian ad litem work where we have a case and we both work as guardian ad litems and we work together. And Jim and I have had many discussions about what we think each other's biases are. And I'm not going to say what those are.
No.
But those are conversations he and I have, and we recognize them in each other. And then we also kind of, when we work a case, push on each other because I know what his biases are after working with him for so long, and he knows what mine are.
Let me guess, Jim. One of Patty's biases is she's too tolerant of stupid men.
that's number one.
Well, she's partnered with me.
No, when I was doing guardian work by myself, every time I found myself leaning towards one decision or another, I'd push back and push back and push back. Now I've got Patty to push back, and we bounce each other. And what have we done? A couple of dozen cases together, probably.
And y'all have done
We've never disagreed.
Y'all have done some high-profile cases too.
We have.
Some big cases.
Some complicated, we'll call them complicated cases with a lot of complex issues. Okay, well, how does this process work, right?
Yep. Okay.
Because that's a big question, and we get that question a lot.
Yeah. Well, first you get appointed.
Sure.
And the court order gives you a lot of authority as to who you can talk to and how you can talk to them.
Any limits on who you can talk to?
Generally not. You can even get confidential records from places like the Department of Family and Children Services with a court order because you are the guardian. The rules give you authority to file motions, to issue subpoenas, to go after whatever information you think is necessary in order for you to come to a conclusion as to what's in the best interest of the child. So you first we send out a questionnaire to the parents to kind of get in the ballpark. We then meet with each of the parents and follow that up. Each of the parents give us references that they want us to talk to. They tell us counselors that the kids are involved. We learn where the kids go to school, who the athletic coaches are there daycare providers, are there nannies or whatever, and we talk to whoever has a good interaction with the child or children and can give us some information. The best sources are third parties. The best sources are non-parents, non-relatives that are involved with the child.
Yeah. Have you ever had a witness refuse to talk to you?
Yes.
Just said, I won't, or I won't, or...
You're finding it more and more with some counselors that they will, even their contract with their client or patient, it says, I will not talk to guardian ad litems and I will not go to court.
Have you ever had a party refuse to participate in the process?
No.
See, the problem with what you just said, well, yeah, if the person hiring the counselor is signing an agreement that I won't talk to guardians, I won't go to court, okay. You can't force someone to talk to a guardian. But have you ever seen the case where the lawyer says, okay, here's a subpoena, you're coming to court anyway, and then the counselor says, no, I can't be made to go to court because I signed this agreement with the party. And then the other attorney tries to enforce that and says, this party signed an agreement with the counselor agreeing they wouldn't bring him to court, so they're barred from doing that. Does that ever happen?
No, what I've done one time is I got one of the parents to waive that provision to sign another release for the counselor, and I told the counselor, either you talk to me or I will subpoena you for deposition.
What about you, Patty? Have you had it?
I've seen it where it's played out where one of the parties then subpoenas them to court, but I've never seen it play out as far as you're saying, where then the issue got before the judge.
They feel like it imposes on their relationship with their therapy.
And I understand that. If I were advising a counselor, I would say your contract should say, by signing this, I will talk to the guardian because I won't be subpoenaed to court. Yeah. And then just see how that plays out. Because if you talk to the guardian, that's the whole idea, is you don't have to go to court.
That is.
Right.
Well, and see, what I do wonder about some of these is, if somebody's talking to a counselor, therapist, somebody, and they have signed that in this agreement, but all of this predates any sort of litigation, and they don't really even know what that means.
Right. Yeah.
But then a year or two down the road, now we're going through this custody dispute. We have a guardian ad litem, and it's, I didn't even know what that meant when I was signing it. Like, I didn't even know what a guardian ad litem was.
Yeah.
But I think I gave you most of the sources that we talked to and try to talk to, and then we try to come up with an idea within our own self, our gut feeling, and what recommendation we make to the court.
Yeah.
And we generally review that with the counsel attorneys first to see what kind of pushback we get. And we also ask, are there anybody we missed? Or given what we are leaning towards saying, are there other people we should talk to? Because that guardian ad litem recommendation is not final until you submit it to the court. So you can always get new information. And in some cases they do. People just say, well, that's not right, but then they start misbehaving or something.
Do you talk to the children?
Sometimes.
Okay. Why not always?
One, some of them are too young.
Yeah. What's the cutoff, you think?
I don't think. The youngest child I visited with, I think, was a third or fourth grader.
Okay.
Generally, they don't know what you're talking about. They don't know what to say. Sometimes it depends.
They're like, who is this strange man?
Exactly. And or depending on which parent that child has been with the latest, they know what to say.
Well, okay, let's talk about that. How often do you see that where the parents are coaching the children?
Not that often, but it's too frequent. And I see it, you find it out just by, it's almost parroting.
Using the same words, phrases, and... Yeah.
I had one child come up to me, or I was talking with him. I think the child was 10 years old. And he says, I want joint legal custody equal time. And started using all these custody words.
Oh, my goodness.
And it's a red flag.
Yeah.
Yes,
yeah, sure. Yeah. So do judges always follow your recommendation?
No. Like I told you in my first case, he didn't. And I've had about 3. I had one case with a Cobb County judge that it was the 5th time the case had been in front of the judge.
Okay.
And when it was over...
Meaning multiple different cases or within the same case?
Multiple different cases, modifications and modifications. Okay. And the judge finally looked at me and said, I appreciate your hard work. I appreciate your recommendation. I know this case better than you do.
Oh. Well, I think the judge kind of had a right to say that.
Yeah, absolutely.
Yeah.
My wonder was, why'd you appoint me in the first place?
Yeah. But wait a second. You said you think that there's been about 3 where the judge didn't follow your recommendation.
That's probably underestimating, Patty. Those are the 3 that come to mind.
Still, you said you've done probably 150 to 200 guardian ad litem cases, which I think has probably been more than that. That's almost... that's a really low percentage.
It is.
You stop and think about it. Because I know one of the things that we talk about as advocates with our clients is, this is what the guardian ad litem is recommending, and you may not like it, but the judge is most likely going to follow the recommendation of the guardian ad litem.
Well, unless, as Steve was saying earlier, you've got some good ammunition to call into question the guardian ad litem's recommendation or the work the guardian ad litem has done. I've had to go to trial on probably at least a dozen cases.
I'm surprised it's not more, actually.
That's all I could remember. I started trying to count.
Yeah.
And once you make a recommendation, up until the time you make a recommendation, you're everybody's friend.
Oh, yeah. and all your jokes are funny.
Yeah. But after you do that, you're kind of adversarial with at least one side.
Well, tell me.
And I've been called some interesting names in court about my testimony and my leanings.
I bet you have.
Well, tell me this. I know that one of the things you also do for our firm is you head up the internal education for our younger attorneys.
Oh, see, he was good.
What do you see? It could be younger attorneys or even older attorneys do, but let's focus on younger attorneys at least first. What did they do wrong in interacting with guardians?
I think young attorneys and even older attorneys, they step back and say the guardian has the case, I shouldn't do anything. I think every attorney should stay in touch with the guardian. Now, not harassing, not arguing, just say, has my client given you all the information you need? What can I supply for you?
I'm going to tell you that the first time I encountered a guardian was in a really bad legitimation case, and a guardian was appointed, and I had no training on how to interact with the guardian, and this was about 2008. I had no idea how to work with a guardian. So what did I do? I just decided, I'm going to sit back and wait and see what the guardian does, and I'm just going to stay out of the way, which is exactly the wrong thing to do, which is exactly what you're saying.
Well, and also, most guardians start out with a questionnaire.
Yes.
Don't let that questionnaire go to the guardian without the attorney reviewing it.
Right. Well, the first thing I do is I try to have a hand in who we pick as a guardian. Then I talk to my client at great length about the guardian process. But then once all that begins, yes, I do like to see the questionnaire before it goes to the guardian. I don't like to be one of those attorneys that says I have to be on every phone call and at every visit with the guardian. I think that sends a bad message. But I do say to my client, if you're not sure what you're sending to the guardian is entirely wholesome or good, and you want me to proofread it first, I will.
Picking up on that, ask your client to also send something to you, everything they send to the guardian.
Oh, yeah, copy me. Yeah, copy me on it. But if you're not sure that you're sending something that you should send or it's not worded properly, let me look at it first. I'm happy to do that. It's my job. But the other thing, and I've hit on it on previous episodes, is I believe that there are certain points in the case where you have a piece of evidence or a thing occurs or there's an issue that arises. I believe in documenting it and sending it to the guardian in written form, not an email, but usually a formal letter that says, this is the issue, this is how I see it, what are your thoughts? Or naturally you would agree with me, wouldn't you? Things like that. And I'd probably send, anywhere from 2 to maybe 8 of these letters to a guardian throughout the course of a case. And that basically if the guardian is not going my way or not totally my way, that basically becomes, I pull those letters out of the file, that basically becomes the outline I'm using to question the guardian in court. So that day before trial or week before trial, I don't have to sit there and think, gee, what do I need to ask this guardian? I pull out those letters and go, was this answered? Because if the guardian ignored it, that's beautiful for cross-examination. You didn't even respond to me. You didn't even address this issue. Or you did respond and you responded this way, and let's talk about that. So I'm laying the groundwork for myself months in advance.
I have never had that experience. I haven't had many independent phone calls with each attorney.
Yeah.
And notes and everything, but
we had a case where the
Did we?
attorney would send
I did
us
not
a
recall
letter.
it. Okay.
Yeah,
Jim.
But actually, I like it, because one, it may bring issues to our attention that because sometimes the parties don't know what to tell us.
Remind me, did you copy opposing counsel, or is that just your letter to the guardian?
I will tell you that unless the agreement is that counsel is copying each other or the guardian insists on it, almost never copy the other attorney. Let the other attorney discover it, if at all, in due course. I've talked about it on a previous episode. I had a very contentious and tragic case where both sets of parents were killed and 2 sets of grandparents were fighting over a small girl, a very young little girl. And Melody Swilling, a fine guardian, was the guardian, and she was headed my way on the case. We were not opposed to each other. Nevertheless, she was in court, and I did have to ask her a few questions. And I said to Melody, on such and such a date, I sent you a letter addressing this issue. And she smiled and goes, yes, I know. In my office, we refer to those letters as Steve Grahams. But I tell other attorneys, you need to be doing that. Yeah. You need to be documenting your file with very specifically unemotional letters about this is an issue. How do you come down on this? Because you need to be pushing the guardian, driving the guardian with information, kind of hemming the guardian in like a shepherd. Where are we going with this?
No, and sitting here, you could be protecting the guardian from running down some rabbit holes. If your clients are making these allegations that actually are not true, you've investigated and say, hey, this seems to be legitimate. Right. So you could be helping the guardian in that way.
Yeah, it's not always adversarial towards the guardian. It's often couched that way. But yeah, you could be protecting the guardian, limiting the guardian's limited protecting their limited resources.
Well, and if these are going to be issues that you are going to bring up at trial, then if we're guardian ad litem, I'd rather you bring them to my attention so we
absolutely.
Absolutely.
Well, I'll tell you right now that 90% of what I'm going to ask a guardian in a trial you already know.
Yeah.
Just pull out your letters from me. It's right there. Yeah.
So Jim, we're almost out of time. Give us, you mentioned, to attorneys, stay involved in the process. What other tips do you have for attorneys in dealing with guardian items and party?
Super guardian that you are.
Superhero guardian?
Give the process some time.
Yeah.
I'm not an advocate of quick judgment. And you've got to give it some time. Both parents will be living in a fishbowl.
Yep.
And if they can't, quote unquote, behave themselves and be the people that they're trying to make you believe they are.
That's what I tell my clients all the time. I say, there's no drive-through window on a guardian.
Yeah. And a guardian has to be skeptical of everything they get, particularly from aligned parents and relatives. That's why third parties are so good.
Which one of you was it that you walked up to one of the party's house and you caught the opposing party placing beer cans in the bushes?
No, that was a client, and our guardian was Bobby Burnett.
Bobby's a great guy.
Well, also remember what Bobby said about making cases last a little bit longer.
Yeah.
That some people like sphincters.
You can only hold your sphincter so long. That's what Bobby
No,
said.
yeah. I think a case needs to take 4 to 6 months, probably. I like also in all guardian cases, and I know y'all have had us part on this, I'd like to have a temporary order in place.
To see how the parties behave.
Exactly.
It's only the fate of a child, so why should we rush it?
Well, that's important for you to point out, Steve. Right. 2 parents are asking somebody that's never met them or their children to make a recommendation to the court. Yep. And so we have to do our homework, and we have to do it digital.
You remember Judge C.J. Becker, DeKalb County?
Yes, ma'am.
She used to get mad. I'm a sir. You could say yes, sir to me. She used to get mad at people coming in the courtroom, and she goes, "You want me, a complete stranger, to decide the fate of your child? What could be more child abuse than that?"
Yeah.
And you could agree or disagree with Judge Becker on certain things, but she was right about that.
Well,
what a pleasure to have
it's
you.
been a great episode. We got the old man of the mountain to come down and share his wisdom with us. Jim,
Thank you for having me.
thanks for joining us.
Glad to be here. Thank you.
All right. Peace out, Girl Scouts.
Lawyers Without Billboards.
That's it for this episode of Lawyers Without Billboards. If you found this episode helpful, make sure to follow and subscribe on Spotify, Apple Podcasts, Google Podcasts, or wherever you get your podcasts. For more resources or to get in touch with us, visit shewmakerandlewis.com. Thanks for listening, and we'll see you next time.